Hello friends, a warm welcome to all of you. I hope you have been studying well and getting your concepts both strong and cleared with due course of time. Welcome to Ansarkari. Today we are taking up another very important topic, that is writs in the Indian Constitution. Why writs become important is to be seen in the light of the fact that society is complex. Not that today it is complex, it was complex in the earlier times also. But if you see in the 19th century and 20th century, then the functions of both state and society, they have multiplied numerous times. It is in this context that the role of the state in context of India is to be a welfare state. The role of the state is to bring justice and equality to all individuals, and that is to the whole society. It is in this context there are certain powers and prerogatives which are given to certain organs of the constitution, by which you can say that those activities will be carried out. So in short, what we can say is that there are certain rights with the individuals and there are certain responsibilities with the state. Now whether state is carrying out that responsibility meaningfully or not, that has to be seen. That is why writs are to be seen in the context of a kind of a regulatory power. They are seen in the kind of a prerogative nature, and it is in this context that Indian Constitution provides for different kinds of writs. They are very much fundamental to the functioning of Indian Constitution. So we have to understand that what a writ is. So writ is a kind of a order. It is a kind of a directive by judiciary, because court exercise judicial control over administrative activities. We have to understand that any kind of action must comply rule of law. So in order to see whether it is complying rule of law or not, there are different parameters. Whether any kind of favoritism have been done, whether there have been improper implementation of the law, whether it is in excess of the law, whether the person carrying out activity is allowed to do so or not, or whether any other kind of malfunctioning is there. It is all these areas which comes into picture when we talk about writ. So writ can be filed in such circumstances. So it is there for Supreme Court and also for High Court, and not only for fundamental rights but for other legal rights also. So because we are talking about protection of fundamental rights, so we have to understand and know that actually under which article these writs are mentioned. So that is Article 32. It is because Article 32 provides the right to constitutional remedies, which means that any person, or you can say every citizen of India, has right to move to Supreme Court and also to High Court for getting his fundamental rights protected. Such is the gravity and sanctity of this article that it has been called as the soul of the Constitution and very heart of it by Dr. B.R. Ambedkar. Now we just see that under which articles these writs can be issued. The writs that we are talking about, which are mentioned in Article 32 of the Constitution, they includes Habeas Corpus, Mandamus, Certiorari, Prohibition, Quo Warranto. So these writs which are mentioned in Article 32, they talk about protection of fundamental rights. And similarly, High Courts also talk about the same. That means you have the right under Article 226 also and under Article 32 also in order to protect your fundamental rights. Also here we can say that the power to issue writs, they can also be extended to any other courts, that is local courts also, by Parliament, by making a law for local limits of jurisdiction of such courts. But very important for examination, we have to note that court martial, that is the tribunals which have been established under military law, have been exempted from the writ jurisdiction of the Supreme Court via Article 33. It is in this context comes the role of Article 139 also. Under Article 139 on Supreme Court, there can be conferment of powers to issue certain writs other than the purposes which have been mentioned in Article 32. So these five writs, they form the core of constitutional values as far as regulation of administrative system in India is concerned. You can say these are the benches, these are the key elements which make the administrative system go, because if one is going to come by a regular procedure, then complete anarchy, or you can say breakdown of constitution can be there. That is why these writs are extraordinary powers. They are to be used under extraordinary circumstances. That is why under Article 32 it is mentioned that they cannot be suspended. otherwise mentioned in the Constitution. So you can say whims and fancies of the administration or any kind of excesses of the administration is being taken care of by these writs both at the Supreme Court level and at the High Court level. So as we have seen, the power to issue writs is there with Supreme Court also under Article 32 and it is with High Court also under Article 226. We have seen that these 5 writs, they can be issued by both Supreme Court and also by the High Court. So what is the difference? How the jurisdiction of Supreme Court and High Court differs? So you can say the Supreme Court is having a narrow writ jurisdiction. Why we are calling it narrow? Because it is there for the enforcement of fundamental rights only, whereas High Court can give directions not in the context of fundamental rights but also in the context of legal rights also. That means High Court is having a wider jurisdiction in terms of writs, but otherwise in terms of territorial zone it is having a narrow jurisdiction. If the cause of action is in the territory of that High Court, then it has all the power to issue directions and writs as the matter may be. So you have to see that the Constitution is providing very beautifully power to the judiciary so as the rights of people and citizen can be protected under all circumstances. So how we can sum up whatever we have read till now is that the violation of fundamental rights can be taken up under Article 32 by the Supreme Court, but if there are remedial measures available, then one has to first go to the High Court, and then later on obviously if there is no more remedy available, then one can go to the Supreme Court. Under High Court there is a wider jurisdiction and under Supreme Court it is only for the fundamental rights. But it is in this context we have to see the powers which are conferred to the High Courts under Article 227 also. The power of superintendence is conferred upon every High Court by Article 227, which is a supervisory jurisdiction, which is intended to ensure that subordinate courts and tribunals, they act within the limits of their authority and according to the law. That is what we can say is that every High Court has a power of superintendence offered to courts and tribunals throughout the territory in relation to which it is exercising its jurisdiction. So Article 32, Article 226, Article 227, they are very much important to be seen in the context of functioning of the Constitution. So our revision point is that we have to see Supreme Court jurisdiction is the territory of India, High Court's jurisdiction is the territory under its authority. Now, as we have mentioned in the beginning, how many types of writs exist in the Indian Constitution? There exist total 5 types of writs, that is Habeas Corpus, Mandamus, Prohibition, Certiorari and Quo Warranto. We can say that all these 5 kind of writs, they have evolved from the common law of England and also monarchy. If we see today's time, then there are some countries which are following writs and some are not following. Even in the context of the United States of America, there is usage and mention of writs in the American Constitution. So one more recap for you is that we have the 5 writs: Habeas Corpus, Mandamus, Prohibition, Certiorari and Quo Warranto. So Habeas Corpus, it is going to see the legality of detention. That means to have a body. That means whether a person have been detained under procedure what have been laid down. That means if there is any arrest which is in the case of violation of law or any kind of arrest is unconstitutional, then it is going to be under operation. You can say it is going to be put against both public authorities and also against individuals. For examples, since the coming of J&K as Union Territory, number of habeas corpus players have been filed in the Jammu and Kashmir High Court. Similarly, when we talk about emergency, then under MISA Act, large number of habeas corpus players had been filed. So this is very fundamental with respect to protection of both fundamental rights and also for human rights. In fact, courts have been gone to the extent of providing compensation in certain cases. So as we have just said, in order to recap, we can say that it can be issued against both public authority and also against private individuals. We have to see India as a growing nation, India as a developing economy and also a democratic power, that habeas corpus plays very important role in maintaining a clear cut understanding of faith and also trust, not only on judiciary but also on the whole public system. So Mandamus is a writ, that means we command. That means this writ is asking for following a command, following a order, that is to a public body, for example any PSU, or to a corporation, that means any municipal corporation, for example BMC or MCD in Delhi, or to any inferior court, or you can say to any administrative tribunal. So it is going to give command to the public authority to perform legal duties which it has refused to follow or it has not taken up. This is a very important in context of carrying out administrative action. But mandamus cannot be issued to private individuals because they are not carrying out any public purpose, they are not carrying out any kind of public or constitutional duty. Similarly, it cannot be carrying out to non-statutory department because there will be no clear-cut power, obligations or duty. And next point is also clear, the duty, if it is not mandatory and discretionary, it cannot be applied. Similarly, contractual obligation and also against president, governor and for that matter against the chief justice of high court. So we have to keep in mind the nature of the work that mandamus asks for: commanding, that means carrying out of public duties, carrying out of such civil duties which can bring good to the nation and to the society. So we have to see that the writs which are provided, what we have seen till now, whether it is habeas corpus, whether it is mandamus, they are providing more and more clarity to the constitution. In that sense, we can say prohibition, which is forbidding to carrying out any kind of jurisdiction or any kind of action before it is starting. That means it is issued by higher court to a lower court which is in the context of exceeding its jurisdiction which it is not possessing. Here we have to see that if the order have already been carrying out, then the writ of prohibition will not come into action. Or what we can say here is that inferior courts, they are prohibited from carrying out proceedings in the excess of their jurisdiction. It will not be wrong to say that prohibition is actually preventive in nature. You can say that it is actually stopping the action to be, or you can say the result to be carried out. However, it can only be issued against judicial bodies and against quasi-judicial authorities, because that is from there you can really stop the action and take it with itself. That is the power with high courts and supreme courts. So it cannot be issued against administrative bodies, legislative bodies and private individuals and bodies. So another writ which is very much intricately linked with prohibition is certiorari. If you cannot prevent, at least you can cure the action. That is why the higher court can ask a lower court or tribunal to transfer the pending case or the case which is going on to later, or it is going to quash those orders. So you can say the required record of proceedings or orders in the inferior court, they are brought to the higher court, and if they are found to be defective, they are completely quashed. So you can say certiorari calls for regard and examine. It is going to see that whether it is going on the correct lines or not. So you can say both these remedies, that means both prohibition and certiorari, is very much integral to the part of the working of administrative system because there are many cases which are going to be there, which are to be seen in this light. So what we can say here is that if the action have already been taken, so it will be seen in the light of curative, that is certiorari, and if the action have not been taken, then it is preventive in nature. That is why both certiorari and prohibition, they are very much crucial to the functioning of the administration. We have already said that certiorari can be issued against quasi judicial authorities, administrative authorities, and judicial bodies, and it cannot be issued against legislative bodies. Please, I am repeating, certiorari cannot be issued against legislative bodies because it is not under their domain, because their work, their policy making, this is all very much broad. The law making activity is very much broad, and it is very much essential to be deliberated upon. So you can't really say that what is exactly going on or not until unless it comes into the form of law. Similarly, one more writ, that is quo warranto. By what authority or warrant? That is, the court is going to inquire into legality of a claim of a person to a public office. Public office means whether you talk about appointment of lokayukta, you talk about appointment of information commissioner, or whether you talk about appointment of a deputy chief minister or a chief minister or a cabinet minister, or for that matter any public office. There a writ can be filed and it can be asked in the court that by what authority that person is continuing his position, or you can say that it is only in the case of substantive public office of permanent character created by a statute or by constitution, as I have already mentioned. You cannot say that some contractual government job is there and you are going to ask that. Substantive public office, it is going to have a substantive element in the sense great gravity and impact on the making of policies and also working of the government system. So you can say that anybody, any interested person can go and ask, not just the aggrieved person, and can ask that by what process or by what authority that person is actually taking up that seat. So quo warranto cannot be issued for ministerial or private office is to be seen, because for private office obviously it cannot be issued, but for ministerial office it is a matter of debate, because in the recent past the Madras High Court went on to ask that by what virtue the deputy chief minister was holding the position. So we can say that the writs are going to be a very important element of the understanding of the constitution. They have wider ramifications and they are definitely going to make an impact on everyday life of the people. Thank you for giving me your precious time and understanding key concepts which are very much relevant for both objective questions and also for long answer type questions. Looking forward to your comments and also your feedback. Do not forget to like, share and subscribe our channel. Thank you very much. Wishing you all the best for your studies.